Good morning, everyone. Thank you, Kathy. My name is Mariam Qureshi. I'm Senior Counsel, and I'm in the Westchester office, and I practice in the School Law Practice Group. Thank you so much, everyone, for joining us this morning. I know it's very early in the morning. And I'm here with my colleague, Ayana Thomas.
Good morning, everyone. Again, my name is Ayana Thomas. I'm in the School Law Practice Group. A large part of our practice focuses on this topic today, which is Section 504, and also special education law, where we're involved in all aspects of special education, even from the beginning, where we attend CSE meetings or meetings with the 504 teams, and all the way up into when a parent files a due process complaint against a school district.
Thank you, Ayana, and that gives us a great segue to start the session today. So today's session is about the Section 504 of the Rehabilitation Act of 1973. The relevant federal disability laws that go along with Section 504 are the Americans with Disabilities Act and the Individuals with Disabilities in Education Act, also commonly known as IDEA. Next slide, please. So what is the difference between Section 504 and IDEA? To be eligible under IDEA, a student must meet one of the 13 categories of disabilities listed under the regulations and the statute. And once the student, and the other part of it is that the student must be shown to be in need of special education and related services as a result of his or her disabilities. Next slide, please. Section 504 prohibits discrimination on the basis of disability in programs or activities that receive federal financial assistance, federal funding, which also includes school districts. A student may possess a qualifying disability under Section 504, and even if they do not meet the criteria of educationally disabling condition under the IDEA. Generally, the reverse is not true. Generally, if a student has been classified under IDEA, they generally also have, are entitled to 504 accommodations. The reverse is not necessarily true. So that if a student has a 504 accommodation, it doesn't always necessarily mean that they may qualify for IDEA special education program and services either. Section 504 borrows its definition of disability from the Americans with Disabilities Act and its amendments. So how does one be eligible for Section 504 accommodations? In order to be eligible for Section 504 accommodations, an individual, including a student, must meet one of the following criteria. The student must have a physical or mental impairment that substantially limits major life activities. They should have a record of such an impairment or are regarded as having such an impairment. Let's talk about what are physical or mental impairments. Under Section 504, physical or mental impairments are defined as physical impairment is any physiological disorder or condition, cosmetic disfigurement, anatomical loss affecting one or more of the following body systems: neurological, musculoskeletal, special sense organs, respiratory, including speech organs, cardiovascular, reproductive, digestive, genitourinary, hemic, and lymphatic, skin, and endocrine. And mental impairment is defined as any mental or psychological disorder, such as mental retardation, organic brain syndrome, emotional or mental illness, and specific learning disabilities. There are also certain short-term or episodic impairments that could qualify for accommodations under Section 504. So what would be an example of a short-term impairment? For example, student broke their leg. That might qualify a student for a 504 accommodation. Accommodation in situations like this would depend on how long the impairment lasts and how limiting it is. Episodic impairments, on the other hand, are things like asthma, which may qualify a student for a 504 accommodation. So in order to qualify for a 504 accommodation, the impairment that the student has, whether it be physical or mental, must substantially limit a major life activity. So the definition is substantially limit. So turning to what are some of the examples of major life activities. Major life activities are functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. As you can see, learning is just one of the major life activities which triggers the eligibility for a student to be assessed for 504 accommodations.
So similar to the IDEA, under section 504, there are child-side obligations, and under regulations, it's defined as undertake to identify and locate every qualified handicapped person residing in a recipient's jurisdiction who is not receiving public education. And for best practice, whenever a parent makes a referral to the section 504 or team or to the CSC looking for accommodations or special education services, it's best to first evaluate whether the student is in need of an IEP under the IDEA first, and then say the student is ineligible for special education service under IDEA, then look to see whether the student's eligible for accommodations and special education services under section 504. Also, like I said before, the obligation is very similar to IDEA. So under the regulations, school districts may use the same evaluation process to evaluate students under the IDEA for students with section 504 plan. So evaluation is the initial step in determining whether a student is eligible for special education and related services. The tests and other evaluations materials should be tailored to evaluate the specific areas of educational needs, not merely designed to provide an IQ to figure out what is the student's educational capacity. So any evaluation to measure specific areas of educational needs may be appropriately provided by trained individuals. Certain evaluations are child tests, which evaluates aptitude and achievement tests, physical conditions, teacher observations / recommendations, work samples, report cards, and medical records. So these are the type of evaluations should be used to determine whether a child is eligible for special education related services or accommodations under section 504. So basically the purpose is to have enough documentation to figure out what is the child's specific needs and to understand the student's needs, abilities, and behaviors. As I mentioned before, under section 504, follow the same process under the IDEA, where evaluation is defined as the same procedures, where basically the whole purpose is you're trying to determine whether a child has disability and the nature extent of what needs the students have and whether they need special education and related services. Whenever a parent or guardian presents outside evaluations, including scripts from outside medical doctors, that may trigger further evaluation. So say, for example, if you had your meeting already to develop the child's 504 plan, and then maybe a month or so, a parent presents additional information, different additional data or evaluations. This 504 team should convene and determine whether the 504 plan should be amended based on the evaluation presented by the parent. So whenever you receive new data from a parent or a guardian, the 504 team should consider it and determine whether it's necessary to update the student's 504 plan. As the slide says, treat position notes like any other outside evaluation and convene a section 504 committee. Also, under the IDEA requires a triennial review where every 3 years, the CSC has to determine whether the child is still eligible for social education services and conduct evaluations. Under section 504, there is no requirement for there to be triennial evaluations, the requirement for periodic evaluations. And periodic can mean whenever there's a need for to conduct further evaluations. You could also provide do a triennial evaluation as well, which the IDEA is not required. However, the guidance is very clear that evaluation should not be conducted more than once every year. So you can do it once every year, you do it every 3 years, but it should really be based on the child's individual needs. The next question is, who should be on the section 504 team? So regulation doesn't specify which school staff members who should be on the 504 team, but it does state that the 504 team should include persons knowledgeable about the child, the meaning of the evaluation data, and the placement options. So basically, you want to make sure that anyone who has information about the child's needs, whoever will be interacting with the child, the person who will be developing the 504 should be part of this team. And those people should include, or examples are the child's teacher, guidance counselors, social workers, nurse, psychologists, and specifically whenever a child has health services needs and it's requested by the parent, you should typically have a school nurse or a school medical director or anyone with a nursing capacity be a part of the 504 team to provide expertise on what the child may need and to give information about the child's abilities. So since it's not defined who should be part of the 504 team, the best practice is to think about who will be interacting with the child and who has the most information to share about the child and who will be able to figure out what accommodations or services is necessary for the student.
So the question is, what is the need for accommodations and modifications? The purpose of accommodations and modifications is to level the playing field and to ensure that students with disabilities are afforded an equal opportunity to participate in education programs and benefit from those programs the same way that their non-disabled peers are. So it's really to make the playing field equal for all students. In a dear colleague letter from the Office of Civil Rights from summer 2016, it was emphasized, the Office of Civil Rights emphasized the importance of avoiding boilerplate accommodations. And the purpose is to tailor the accommodations to the needs of each and individual student so that they really meet the needs of the student. So what are some of the examples of these accommodations? There are educational and other accommodations. So educational accommodations are generally accommodations for students who need like building and classroom level or services, testing accommodations, etc. Some of the examples of classroom accommodations are, special seating arrangements, modified class schedules, breaks. Sometimes students' needs are such that they need, breaks in between tasks that they're doing, repetition of directions, testing accommodations, providing extended time. This is one of the most common ones that we see with all our clients, giving them use of break periods, providing a separate location in order to, give the child the benefit of, avoiding any distractions or anything like that. Test directions or questions read to the student. Obviously, this cannot be given for all kinds of testing and certain testing. However, this is, provided. Some of the other examples of accommodations include like providing assistive technology, building adaptations where building accessibility could be an issue for a child, providing, paraprofessional services in some instances where, for a limited time period, a student is not, able to perform a certain task. In those instances, providing those services. Transportation accommodations, by the way, are also an example of 504 accommodations and can also be provided by the 504 team. Similar to IDEA, there are procedural safeguards under 504 as well. And those procedural safeguards are, one, the notice requirement. There is an opportunity for parents to examine the relevant records and to make a determination on what's being used in order for the team to come up with the accommodations for their child. And then if the parents disagree, the process for the parents is to file for an impartial hearing, and that is the opportunity for them to participate and be represented by counsel in front of an impartial hearing officer and, litigate the case. And then a review of the procedure, as in, again, like what resources were used, whether everything was like done the way it needed to be done, like who the team members were, the team members were aware of the students' needs. Everything was reviewed in order to provide the proper accommodations and modifications for the child.
The next slide is going to talk about Section 504 plan. So Mary talked about examples of accommodations, modifications, and all accommodation modifications should be incorporated into Section 504 plan. So the regulation does not require an actual written document, unlike under the IDEA, where the IEP must include all the program recommendations and services for a student. But it's good practice to still memorialize all the accommodation modifications and services into the Section 504 plan. This way, all staff members are aware, who interact with the child are aware of what services the child's receiving and able to implement the 504 plan. Also, unlike the IDA, which especially provides the parent should be a member of the CSC, the parent is not a mandatory member of the school-based Section 504 committee. Although they're not a mandatory member, it's good practice to include the parent in the meetings and make sure that they're actually able to participate in the meeting, ask questions if they're unsure of what recommendations are made, make sure that they're able to fully participate and they understand what services are recommended for their child. What we've realized over the years is that the more a parent it feels like a participant in the meeting, has the ability to provide feedback, to ask questions, they feel more involved. Sometimes they're less likely to sue you under the IDA or under Section 504, but of course you can't prevent a parent from bringing a lawsuit against the school district, but it's helpful. We notice that sometimes parents may not just understand the process, they may not understand, they may confuse the process between Section 504 and IDEA and the services under the IDEA and Section 504, and they just need a better understanding. You know, sometimes districts have meetings back to back to back, and they use acronyms all the time, and sometimes they speak in special education jargon, what I call it, and they don't realize that parents may necessarily understand that lingo. So the next couple of slides can talk about best practices and how to make sure that a parent feels that they're able to fully participate in the meeting. So next, we're going to talk more about Section 504 plans. We want to make sure you have a plan where all staff are aware of the plan and they're able to implement the 504 plan. Anyone who engages with the student should receive a copy of the plan as well, and also confirm receipt of the plan as well. And make sure that anyone who works for the students, that includes teachers, related service providers, or paraprofessionals, understand exactly how to implement the 504 plan, so they should see clarity from administrators and their supervisors, and also want to make sure that the retained documentation illustrates that this opportunity was provided. We want to make sure that down the line, if something happens, that the teacher or providers can say, well, I wasn't aware that this student had this particular accommodation in their 504 plan. Make sure everyone's on board, understand how to appropriately implement the plan. Also want to make sure that teachers are applying the accommodations in the same way, they're not applying it differently. And again, making sure that they had the 504 plan and they're using that as a guide to implement accommodations and services that the student needs. So best practices. Want to avoid using boilerplate accommodations. Again, as we've been emphasizing throughout the entire presentation, you want to make sure that the accommodations, modifications, or any services recommended is recommended and based on the student's individual needs. So it's narrowly tailored to make sure that the student's needs are being met. Also, we want to make sure that it specifies parameters. So for example, it should note the frequency of certain accommodations, the duration of the accommodations, the location of the service being provided, and that goes for the modification accommodation as well. Typically in a 504 plan, there's a box for that. So it's a frequency, you could say that it should be throughout the school day, should be for 5 minutes, should be for 20 minutes, should be for a half hour, should be implemented daily. And then next slide talks about you should try to limit words as necessary, be more specific to when exactly when the accommodation should be implemented. So all the things should be noted on the 504 plan. And also we want to develop a process for ensuring that data is gathered regularly to adjudicate the necessity and effective accommodation. So again, as I mentioned before, if the parent presents new data, or say if the teachers observe new data, the 504 team should be convened and figure out whether the accommodations or modifications of service should be adjusted. As I mentioned before, you want to make sure you don't use ambiguous language such as needed. You want to be more specific, where, say, for example, say this should be implemented daily throughout the school day in a particular location. So again, you want to make sure that the the plan is tailored to meet the student's individual needs. And also say if the student is resistant to a particular accommodation, or say again, if the parent expressed that student's resistant to a particular accommodation, you want to convene the 504 committee to see whether the accommodation should be adjusted as well. Also, like I said, again, it's very important to make sure that the parent feels that they are active participants in 504 meetings. So make sure you have face-to-face relations early in the process. So whenever a parent makes a referral, make sure that the district's in communication with the parent. Again, avoid jargon. Like I said, the CSC use a lot of acronyms. Special education in general has a lot of acronyms. So we make sure that the parent or guardian fully understands what is being communicated at a meeting. And it's best practice as well, like as you're recommending certain services, accommodation modifications, to say this accommodation is being recommended because this child has a specific need in this particular area. And to do that for every accommodation. Also, it's helpful if the parents do sue and request impartial hearing. This way, whenever we have a hearing, there's testimony involved where anyone who's part of the 504 committee meeting can explain exactly why the accommodation modification service was implemented for a particular reason. Also, you want to identify and highlight the ways in which special education can promote progress. As you know, sometimes special education is stigmatized and parents are reluctant to any special education services. And you want to make sure that to explain to the parent that the child can be successful and the importance of why the 504 plan can meet the child's individual needs. Also, you want to emphasize the child's progress, not just at a meeting, but also just throughout the school year. Again, it shows the parent that the school is an active participant and cares about the student's needs as well. Also, want to choose neutral language so it's not judgmental. Again, it's another way to make sure that parent or guardian feels comfortable throughout the entire process.
So discontinuation of 504 plans. Just as it's extremely important when you're creating a 504 plan to review all the information that Ayana just talked about, and and as we've discussed, like tailor it to meet the needs of the student. You also just don't, should not be just discontinuing 504 plan because it's like the end of the school year, and it's basically based on the needs of the student. So the 504 plan should be reviewed annually, and if more frequently if necessary. And at the time of the review, it should be determined if it needs to be amended, the accommodations need to be in place or not. Again, when reviewing the 504 plans, the team should basically be looking at all the information from different resources, such as, tests, observations, work samples, report cards, medical reports, anything that will help the team understand the child's needs, achievements, behaviors, health needs, and then discuss it with the parents and collect all the data. If it is deemed at the point of the review that the child's impairment no longer substantially limits the ability in a major life activity, then a child may no longer be eligible for accommodation under a 504 plan, and in which case the 504 plan can be discontinued. However, again, it's extremely important to collect copious data in all settings and subject areas and review it at the meeting to make a determination that the child's disability is not substantially limiting any major life activity. And again, parents should be a participant and discuss, and any kind of before any discontinuation, there should be a discussion with the parents to make sure that anything that the parents know is brought to the table and discussed.
All right, so thank you again for joining us for our presentation today on 504 plans. And just in sum, because I know that a lot of clients confuse 504 plans from IEPs. IEPs is about whether a student needs special education services and specialized instruction and related services. 504 plans focus on related services, accommodation modifications. So whenever a student needs a special classroom arrangement, a special classroom size, special classroom program, that's when an IEP is necessary. whenever a student just needs accommodations and modifications and they meet have a qualifying disability under Section 504, that's when it's under the umbrella of Section 504. If you have any questions, like feel free to put them in the chat, or if you don't feel comfortable putting in a chat or you don't have time to stay with us this morning, like feel free to send us an email. We're happy to assist you with any questions that you have. Again, thank you again for joining us today.
Thank you.
Anna, there is one question in the chat,
Okay.
and it is, can you please explain what happens in a scenario where a student who is already classified with an IEP then sustains an injury, for example, a broken leg, that warrants short-term accommodations? For an example, students don't have both a 504 and a IEP.
A student may at that time need some sort of an accommodation. So disability is, that's sort of like, whatever the student has on the IEP, the student is getting. But let's say the student broke the leg and it cannot come to, cannot go to the second floor where the classes are. And the student only needs to be in on the first floor. You could sort of, at that point, that could be an accommodation for the child for a limited period of time. And, the child could be, while the child is in a cast, the student could take all the classes or like tests or whatever on the first floor if the school does not have an elevator. So that it could be an example of where a child may need a temporary accommodation, as opposed to, which is going to be distinct from what the services and recommendations are on the IEP.
But the resolution is very clear that just if a student is classified and has an IEP and they may need accommodation under Section 504, you do not need to have an IEP and a 504 plan. So those accommodations and modifications can be incorporated into the IEP, but there's no need to have a separate 504 plan for students already classified. And there's SRO decisions that talk about that in the regulations as well, and it's clearly outlined those areas.
And you can note it in the IEP with like an end date, for instance, if the student is, in this example, if the student has a broken leg and is in a cast for 6 weeks, you could just note that as the end date of the accommodation on the IEP, because that would be something new that would get added to the IEP for a very specific reason and for a certain period of time.
All right, thank you very much. That was the end of our questions. I don't see any more. So as Ayanna said, thank you so much for joining us, and we look forward to having you next month on October 20th for our next presentation. I wish everyone a wonderful day. Take care and be well.
Thank you. Take care.
Thank you.